See, let us continue. We have started our discussion on center-state relations. So, the first aspect of our discussion is the legislative relations. We'll continue with our discussion on legislative relations. Yesterday, we had started legislative relations yesterday, and we had seen two articles here. Article 245 of the Constitution. We have also seen Article 246 of the Constitution. We have seen Article 245 of the Constitution and Article 246 of the Constitution. Article 245 of the Constitution basically details the territorial jurisdictions of the law that is made by the Union as well as the laws that are made by the states. So, territorial jurisdiction of laws made by the Union are throughout the territory of India, whereas the territorial jurisdiction of the laws made by the state are restricted to the territorial jurisdiction of the state. It does not go beyond that. We had also seen that laws made by the Parliament of India are not considered or will not be deemed invalid on the grounds that it has some extraterritorial jurisdiction, it has some extraterritorial implementation. We had also seen what is the meaning of this term extraterritorial implementation. We have seen that as well. Then we had come to a discussion on Article 246 of the Constitution. Article 246 of the Constitution mentions the subject matters on which the laws can be made by the Parliament and the state legislature, and subject matters on which the Parliament can make law is obviously the 7th schedule, and in the 7th schedule the list that is mentioned called as the Union list. The first list 1, which is called as the Union list. Subject matters on which both the Union, that is the Parliament, and the state legislature, both of them enjoy legislative jurisdiction is called as concurrent list or the list 3. The subject matter on which exclusively the state enjoys legislative jurisdiction, the state legislature enjoys legislative jurisdiction, is list 2, that is called as the state list. Similarly, we were also talking about the UTs. We focused on this idea of UTs, and we said that any particular territory which does not fall under the state, the legislative jurisdiction extended there is that of the Union Parliament. So, we say residuary territorial legislative jurisdiction lies with whom? It lies with the Parliament. Clear? Next, Article 247. Article 247. The power of the Parliament to provide for the establishment of additional courts for better administration of laws made by the Parliament, better establishment of laws made by the Parliament, or of any existing laws for subjects mentioned in the Union list. So, the Union legislature, that is the Parliament, also has this legislative jurisdiction to create a law, to enact a law and establish some additional courts, judicial body courts. There is a law that was passed in 2016, you can see that as an example. It has established what? Commercial courts, the coming up of commercial courts in India. So, to resolve disputes that are commercial in nature and has the dispute it has, if it is worth more than 1 crore, any amount that involves more than 1 crore, in that case there can be, those disputes can be resolved in a body called as commercial courts. They These courts that are there, they are established, they are not subordinate courts, rather they are established at the high court level, and they are there, they deal with only commercial disputes. They are called as commercial courts. In 2016, there was a law that was passed by the parliament, and this law created commercial courts. Clear? So when we talk about Article 247 of the Constitution, what does Article 247 of the Constitution, what does it deal with? Article 247 of the Constitution deals with the power of the Parliament to create additional courts, or to create these courts to resolve any disputes that are mentioned either in the on any subject that is mentioned in the union list. Clear? Now, before we move forward, there is also another article that has been added to this particular part of the Constitution called as Article 246A. That is also something that is important. Let's look at that as well. Give a subheading here, right? Article 246A. 246A. Yes, capital A. Not subclause A, 246A. It deals with special provisions. It deals with special provisions with respect to GST, special provisions with respect to goods and services tax, GST. It has been added to our constitution, by 101st constitutional amendment. 101st constitutional amendment in the year 2016. It authorizes the parliament and the legislature of every state, to make laws with respect to GST imposed by the union, or by such states, Next paragraph. Under Article 246A, Clause 2, the Parliament has the exclusive power. To make laws with respect to GST, where the supply of goods or services, or both takes place in course of interstate trade or commerce. Next paragraph, just add here. The provision of this article in respect to GST takes effect after the recommendation given by the GST Council. Now, in this case, when we are talking about the legislative jurisdiction of the union and state, so in this legislative jurisdiction of union and state, it is Article 246A, which deals with the laws that are made for application or imposition of GST, goods and services tax. Obviously, 101st constitutional amendment in 2006, and since the 101st constitutional amendment, we have come up with a structure called as the GST. Now, when it comes to the state and the responsibility of the state to impose the tax, that is the state GST, that is called as SGST, state GST, that is there. Now, with this respect, it is the state legislature It is the state legislature which can make laws on any of those subjects which deals with the state GST. Similarly, when it comes to the C or central GST, the power lies with the parliament or the union legislature. And when it comes to interstate GST, now there is something called as a third category of tax, which is called as IGST, interstate GST. In that case, that right is there exclusively with the Parliament of India. And this comes into effect. That means when are the laws that are made by the when are the laws made by the states? States make laws, or the Parliament makes laws after the recommendation of the GST Council. So have you gone through GST in economics? Have you read GST in economics? No. Okay, when you go through GST in economics, you will find that there were lot of problems with the indirect taxation system that we followed in India. To rationalize that system, we have come out with something called as a GST. And how does this work? It works through a particular constitutional body that we have created under the 101st constitutional amendment under Article 279A, which is called as the GST Council. How it works, I'm coming to it in the later part of our discussion today itself. So in the GST Council, that is there, this GST Council is basically the constitutional body which is responsible for everything with respect to the GST. So what is the taxation rate, etc., etc., it is with respect to the GST Council. However, when the GST Council decides the taxation rate, they decide a band of taxation rate. That means from what will be the minimum and what will be the maximum tax. Clear? It actually decides the band. And what is the exact percentage, it is still left to the states to decide. So when the states are making laws and deciding that particular aspect of it, it is done after the recommendation of GST Council that has come out with the band, and then the state, if it is making a law on it, that is the responsibility of the state legislature. Similarly, when the union is making law on it, on anything that is related to CGST or IGST, it is the responsibility of the Parliament of India. Clear? So after the recommendation of GST Council, both of these authorities are responsible. They can come out with certain laws dealing with it, and it can be done depending upon their subject. SGST, state; IGST, center; CGST, center. Clear? Next, Article 248. Article 248. The Parliament has the exclusive power to make laws, in respect to any matter or subject not mentioned in the state list, or the concurrent list, Clear? Which means, what does Article 248 deals with? In next paragraph, right? It deals with the residuary power of legislation, which under the Indian Constitution, is with the union legislature, in brackets, right? This is an unfederal feature, as if we compare this feature to an ideal federation, that is US, where it is given to the states. Where it is given to the states. So when you look at a country like US, the residuary power of legislation. Now, don't confuse this provision with what we have discussed earlier, that is residuary territorial jurisdiction. That is also obviously with that of the union. So when it comes to laws for the UTs, laws for UTs are made by the Parliament of India. Not only are the laws for the UTs made by the Parliament of India, but also laws which are made on any subject that is not mentioned in the concurrent list or the state list, which means if it is not mentioned in any list, if it is not mentioned in any list, the law or the Constitution of India provides the power to make legislations on it on whom? The Parliament of India. So who enjoys residuary powers of legislation? It is the Parliament of India which enjoys residuary powers of legislation. Example of this is environment. If you look at the subject called as, the matter called as environment, it is not mentioned in any list of the Constitution. So automatically it falls where? In the union. That means the Parliament has now the authority to make laws on it. Clear? Why am I considering it to be an unfederal feature? Only because if we compare this provision to that of US, in US it belongs not to the union or the federal legislature, it is given to the states. Clear? Article 248. Next. Article 249. So is there a need to go through Article 249? जिनको समझ में नहीं आ रहा है, I have already dealt with this. When we were discussing Rajya Sabha, I have already discussed Article 249. In fact, I have not only discussed Article 249, I have also discussed Article 250 of the Constitution. So Article 249, Article 250 of the Constitution, there is no need to discuss that because we have already done that. Article 250, again emergency provisions, we have dealt with emergency provisions there. Clear? Next, Article 251. Article 251, it deals with inconsistencies between the laws made by the Parliament under Article 249 and 250, laws made by the Parliament under Article 249 and 250, and laws made by legislatures of state. Laws made by legislatures of state. It states the legislatures of state can make laws despite prevalence or the use of Article 249 and 250, but if any provision of a law made by the state legislatures is in contradiction to the laws made by the Parliament, then the laws made by the Parliament shall prevail. See, what does this mean? Article 249 and Article 250 of the Constitution, what does these two provisions do? These two provisions allow the Parliament to make laws. Allow the Parliament to make laws on any matter that is mentioned in the state list. Article 249, if the Rajya Sabha passes a resolution, and Article 250 when national emergency is in place. Clear? So in these two cases, the Parliament can make laws on any matter that is mentioned in the state list. Article 251 of the Constitution just mentions that in this case also, that means when the Parliament is legislating on suppose any subject, it does not take away the power of the state legislature to make laws on it. So if under Article 249, if the Parliament is legislating on a subject that is under the state list, example, suppose law and order. If under Article 249, the Parliament is legislating on a subject like law and order, in that case, it does not mean that the state legislature has no right or no jurisdiction over laws to be made on this subject, that is law and order. They can make laws as well, provided if it so happens that the law made by the Parliament and law made by the state legislature, if they contradict each other, then the laws made by the Parliament will prevail over the laws made by the state legislature. Clear? This is what is meant, this is what is mentioned under Article 251. Clear? Again in brackets write an unfederal feature as laws made by the Parliament are given primacy over laws made by state legislature, over laws made by the state legislature, over laws made by state legislature. Clear? Understood this? See, again I am repeating myself. Article 249 of the Constitution, Article 250 of the Constitution, in both these cases, the Parliament can make a law on state list, any matter that is mentioned in the state. Because of Article 249 and Article 250, there is no consequences. There is no consequences on the legislative powers of the state legislature. That means the state legislature still enjoys the authority or the legislative jurisdiction to make laws on those subjects as well, along with the Parliament. However, if there is a contradiction between the laws made by the Parliament and the laws made by the state legislature, laws made by the Parliament will prevail over the laws made by the state legislature. Only in case of that contradiction, it's not that only then the laws of the union will be enforceable and the laws of the state will not. No, it only means that in that contradiction, the contradiction that is there, in case of that contradiction, the laws made by the Parliament will prevail over the laws made by the state legislature. Only in case of that contradiction. Clear? Next, Article 252. Yes, it is applicable for concurrent list as well. That it will be the laws made by Parliament which will prevail. Yes. Article 252. It deals with the power of the Parliament. It deals with the power of the Parliament to legislate for two or more states. If the state legislature passes a resolution to the effect and the Parliament passes an act for regulating that matter, any such act passed may be amended or repealed by the Parliament or adopted or adopted or passed in the same manner but shall not as respect to any state to which it applies be amended or repealed by an act of the state legislature concerned. See, it means basically two things. Suppose under Article 250, what you have written is that if the states want, if one or more state, they pass a resolution empowering the parliament to make a law for them on a matter that is mentioned in the state list, the parliament can do that. So on a request that is made by the state legislatures, one or more state legislatures, a law can be passed by the parliament which will be made for a state subject dealing with that concerned state. Once the parliament has made a law, it can be repealed or amended by an act of parliament, not by the act of state legislature. This is what it means. Clear? So under Article 252 also, the parliament has the power to do what? The parliament has the power to make a law or enact a law for two or more states. How will the parliament to do this? Unlike Article 249 and 250, in which the parliament enjoys these powers either through, suppose, a resolution that is passed in the Rajya Sabha or when national emergency is in place. In this case, even in ordinary circumstances, this can be done, but this can be done by the parliament only when it is requested to do that by a resolution that has been passed by two or more states. Clear? Once the parliament has passed that act, it will be applicable in only those states which have asked the parliament to make a law for them. Only in those states. Once the parliament has made that law, it can be amended by only an act of parliament or repealed by only the act of parliament, not by the act of concerned state legislature. Clear? Suppose a third state which has initially requested the parliament to do that. Now, can that state adopt that act? Yes. If the state themselves, the state legislature passes a resolution to this effect, they can adopt a act of the parliament, a law made by the parliament, which the parliament has made for on the request of two or more states. Even the third state can adopt it. If they pass a resolution to this effect, they will adopt the law which has been made by the parliament for the two or more states, the request upon which they have made the law. Once it has been enacted, the law has been enacted, now the law can be repealed only by an act of the parliament or amended by an act of the parliament. Clear? Understood this? This is Article 252 of the Constitution. Next, Article 253. Yes, there have been number of such cases in which, when I'm saying number of such cases, which means there have been 1970s, there was a law, I think, again, a law which dealt with some aspect of environment itself. There was a law that was made. In Lakshmikant, there are some examples that are given in all these cases. You can see that. I don't remember the laws. Article 253. It empowers the parliament. It empowers the parliament to make laws. For implementing any treaty, agreement or convention with any other country other country or countries or any decision made by any international conference, association or other body. Clear? So who has the exclusive right? Exclusive right is there with the parliament. Clear? Actually, if you look at entry 14 of the union list, you will find that there this subject has been mentioned, international treaties and agreements. And in this case, even if the law that has been made by the parliament, even if it encroaches upon certain powers of the state, it will still be valid. So suppose there is a law that is made by the parliament, the law is giving effect to an international treaty. And to give effect to an international treaty, the law that is being made, it somehow deals with any subject that is mentioned in the state list. But still, while giving effect to an international agreement or any such thing, an international treaty, in that case now the power lies with the parliament. So even if it encroaches upon the state jurisdiction, it will still be valid. Clear? Next, Article 254. Inconsistencies between the laws made by the parliament and by the state legislatures. If in any provision both the state and the parliament, the state legislature and the parliament is competent to make a law, and there is a conflict between the two laws, laws made by the union will prevail over the state. Clear? This is obviously with respect to concurrent list, that if there is a law that is made by the if there is a law that is made by the state over anything that is mentioned in the union list, it is not enforceable, because the state has encroached upon the authority of the parliament. It cannot be done. Similarly, if there is a law that is being made by the parliament on anything that is mentioned in the state list, that also cannot be done in normal circumstances, except for obviously Article 249, Article 250 and Article 252. Except for in these three cases, the parliament can also not make a law that is mentioned in the state list. However, when it comes to the concurrent list, now both of them are authorized to make laws here. And in this case, the laws that are made by the union, if it conflicts the laws made by the state, the laws made by the union will prevail over the laws made by the state. The laws made by the union will prevail over the laws made by the state. Clear? Is it clear? Yes. So when we talk about legislative jurisdiction or legislative relations, you can see legislative relations, it is dealt with in these important provisions. Now these important provisions. See, there are some exceptions that can also be made. That means when there is a law that is made by the parliament, and if the law somehow very minutely also deals with a matter that is mentioned in the state list. Clear? In that case, when that law is being appealed, suppose the state legislature, the states, they appeal the law in the Supreme Court, that it cannot be done. Why? It cannot be done because in this case the law deals with something that is a matter that is mentioned in the state list. it cannot, this provision of the, at least this part of the law is to be held unconstitutional. Then the court looks at intention of the law. Was the intention to encroach upon the state's power, or there has been an unintentional encroachment? If the court finds that the encroachment is unintentional, it's not intentional, and there is no major encroachment, the law is declared to be valid. That is also the case for laws made by the state legislature. If the laws made by the state legislature, they very minutely and unintentionally encroach upon the laws or on any subject that is mentioned in the union list, and if it is appealed in the court will look at the intention of the law. If the court finds that the intention was deliberately to encroach upon it, it will be declared to be unconstitutional. But the court finds that the intention was not deliberate and there has been an unintentional encroachment, the court will also see what is the extent of encroachment. If the extent of encroachment is large, or whether it is very, it's very minute encroachment. If the court finds that it's very minute encroachment and it was unintentional, the court will still declare the law to be constitutional. So there are various, what you can say, legal doctrines that are followed in this particular case. Constitutionally speaking, if there is any law that is made on union list, it is the authority of the Parliament of India, and hence if the state makes a law on any matter that is mentioned in the union list, it is an encroachment and it will be it is unconstitutional, or what is described under the constitutional language as repugnant. Now it is said to be repugnant. Why? It has encroached upon something that is a matter of union list. Similarly, a law made on state subjects. The union cannot make laws on state subjects except for Article 249, Article 250 and Article 252. In these cases, the Parliament can make laws. So if it has been made under these cases, even if the Parliament has encroached upon such ideas, it will not be considered unconstitutional. Otherwise, it will be considered unconstitutional. When it comes to concurrent list, in that case, in case of concurrent list, if there is a encroachment, or there is a, what you can say, there will not be encroachment, rather there will be contradiction. If there are contradictory laws that are that is enacted by the Parliament and the state legislature, in that case laws made by the Parliament will supersede the laws made by the state legislature. But while dealing with this, when any such matter is appealed in the court, in that case it will always be seen what? Intention and the extent of encroachment. If intention is found that it's not intentional and the extent is not huge, it is declared as constitutional. There have been number of such cases as well. Clear? So there are number of doctrines that are followed by the followed by the judiciary while declaring it to be constitutional or unconstitutional. Clear? Understood this idea? So if you look at these provisions deals with the center state legislative relations. There is also something called as Article 255, but it's not that important. So we'll skip what is Article 255. Is the unitary tilt visible? Is the unitary tilt visible? Yes. If you look at Article 249, if you look at Article 250, if you look at Article 252, if you look at Article 254, now if you look at all these provisions that are there, they and Article 248, residuary powers, Article 246 of the Constitution, which gives residuary territorial jurisdiction, all these powers are given to the Parliament. The Parliament has an elaborate legislative jurisdiction which is not present with the State legislatures. State legislatures, their legislative powers are restricted. But when it comes to the parliament has wide range of legislative powers. Now, because of this, because of the manner in which the constitution regulates it, there are 2 or 3 primary concerns that the states have. The concerns are not with respect to Article 249, Article 250 or Article 252. Okay, that is the nature of Indian Federation. But if you look at Article 254 and if you look at Article 248, now Article 254 and Article 248 of the Constitution, which deals with what happens when there is a contradiction of law in case of concurrent list, and what happens when there is a subject which is not mentioned in any list. Now these are the 2 most important, two most important areas wherein the state has problems. Wherein the state has problems when it comes to the manner in which legislative relation between the center and the state works. Why? Because if you look at the original constitution, and if you compare the original constitution to the current constitution, you will find that the matters that are mentioned in the concurrent list, there has been some additions that have been done in the concurrent list by amending the constitution, taking out certain matters which were previously present in the state list and allocating it to the concurrent list. There have been such cases, like when we talk about education. Education was initially a part of state list. Today it is a part of concurrent list. Why? Because it was amended and it was made the part of concurrent list. The problem is not just with the existence of concurrent list. The problem is also with the manner in which the union tends to legislate on the matters of concurrent list. The problem is also with respect to that. Why? Because though the states also have the jurisdiction to legislate on it, but when the union parliament is legislating on any such matters, it does not consult the states. But what is the constitution? What does the constitution visualize? The constitution visualize that both the center and the state will have the jurisdiction to legislate on it. And because the constitution provides for, because the constitution also provides from some additional, some additional institutions which we have not yet seen, we are about to see. Like if we look at Article 263 of the Constitution, Article 263 of the Constitution deals with an institution called as interstate councils. Now if you look at what interstate councils are, this is the very objective of interstate councils. It is formed by the president. It is formed by the president. What is the objective of interstate councils? To look into those matters which are of common concerns of center and state, and those matters which are of common concerns of the states. So this is the very objective, that okay, there is an institution that has been visualized by the constitution, an institution which may be visualized, which at that particular time may have been visualized for this very reason, that there will be some matters which are the part of concurrent list, or there will be some overlapping matters between the center and the state, and these matters will be resolved through an institution called as the interstate council. But we have not used that. And whenever the state union is legislating on any subject that is mentioned in the concurrent list, they do not consult the states. They do not consult the state. Till very recently, there was no institution which could forward this cooperation between the center and the state, and the interstate council, which is visualized in the constitution, was not used. It was not used. So if you look at this particular, in fact, interestingly, the interstate council in India was for the very first time used in the 1990s, not before it. Go back to our discussion on this idea of competitive politics and existence of combative federalism. Now, what was the phase? 1967 onwards. So during this particular phase where we were in a state of combative federalism, that was the time wherein we should have used interstate councils, but it did not come into existence then. It did not come into existence then. The president never appointed this council, did not notify it. It was never in existence. So in the state of, or in the manner in which our federation works, it requires, now this federation that is there, it requires a specific dedication from both the sides, from the center as well as the states, to do what? To take initiatives to forward cooperation, because otherwise the powers are concentrated with the center. So center, if it's the center wants, the union wants, they can use these powers in the manner that they like. But this is not what is the objective of our constitution. The unitary tilt does not have the objective to establish the fact that the state legislatures are inferior to the parliament. No. The unitary tilt is only so that, looking at our history, the history before the constitutional idea. So the kind of integration that we went into, there were a number of states that were integrated. Some of them were forcefully integrated as a part of India. And also because of the problems that happened in the pre-independence period, the law and order problems, communal problems, all looking at all these aspects, we opted for a unitary tilt. But this unitary tilt was not because, or not to establish that the state legislatures are inferior, but because we have not used the mechanisms that are available in the constitution itself to ensure better relations. What we find is that the states, they have some concerns, they have problems with respect to how this legislative relation works. And the most important problem here is the existence of concurrent list, wherein even the states have the right to legislate. But what happens is that the constitution says that the states, laws made by the states are inferior, and if they contradict the laws made by the parliament, it is not enforceable. Laws of the parliament are enforceable. Now in this case, what is the result of it? The result of it is, it actually disturbs, or in some way creates certain concerns for the states, that we are legislatively being dominated over by the union parliament. Similarly, residuary powers. Now this residuary powers, first of all, first of all we should appreciate this idea. There are two things here. First of all, we should appreciate this idea that the Constituent Assembly knew that there are certain matters which can even fall outside these three lists. And because constitution will not be something that would that would be a static document, so they did what? They conceptualized this, that okay, anything that is residuary, there will be an idea called as the residuary list. First of all, this should be appreciated. It points out to the far-sightedness of the Constituent Assembly. But the second problem with this idea is that because of this very evolving nature of the society that we live in the environment that we live in, what is needed is frequently to redefine this. Because today, today environment is so much of a concern for us. Now environment is so much of a concern for us, but it is a part of residuary list. So when we have already conceptualized these, that is okay, there are certain subjects that are outside, what we need to do is we need to amend the constitution and make it a part of either union list or state list or concurrent list. Because 70 years, see, 70 years have lapsed since the constitution has come into force. In this 70 years, the very nature of the existence of human beings have been transformed. It has transformed completely. And hence there is a need to do what? amend, look at those issues which are not the part of residuary, not the part of list's 7th schedule, and amend the constitution to make it a part of 7th schedule. Why? This will bring about some objectivity in how these matters are to be dealt with. This will bring about certain objectivity as to how the matters are to be dealt with. Otherwise, the Union Parliament, in just because it has residuary jurisdiction, it has a very expanded ambit of its legislative powers. So there is a need to do what? Objectify the idea of what is residuary list. Because when we conceptualize this idea, it is not because the reason is not that the Constituent Assembly wanted to give powers to the Union. The reason is that they knew that obviously the society is going to grow, there will be evolution, there will be certain things which today we cannot conceptualize, or we think that is not that important. Tomorrow these are things which are going to be important, and hence there should be a residuary list. That is absolutely fine. But when we talk about the residuary list, not all residuary powers should be given to the Union, because when it comes to governance, the states are a major stakeholder there. You cannot ignore the states. So when we look at this legislative powers are a problem because of these two specific reasons. First is the existence of obviously the manner in which legislations are taken up in concurrent list, and second of all the residuary list that is there. Also, if you look at the subjects that are mentioned in the union list, they are much more than the subjects that are mentioned in the state list. I think there are 100 odd items that are mentioned in the union list. 106 odd items. You can see that, you can just check that fact. And there are around 60 or 61 items that are mentioned in the state list. So that there is a difference between that as well. That is also something that is needed to be redressed. If you look at the Punchi Commission recommendations here, Punchi Commission specifically stressed on the use of interstate councils. Two major recommendations were basically, specifically with respect to concurrent list, they said that when you are legislating, when the center is legislating on concurrent list, they should evolve a mechanism to consult the state, and that mechanism there will be the interstate council. They stressed on it that interstate councils should be used. Interstate councils should be used. And they also gave another recommendation, which was giving co-equal status to the Rajya Sabha. That means in all cases the Rajya Sabha should enjoy equal legislative powers to that of the Lok Sabha, but ye kabhi nahi ho sakta. Obviously, we have seen the logic behind not giving financial powers or political control to the Rajya Sabha. So that will not happen. But one very important recommendation that Punchi Commission gives, it is with respect to this very idea, that is existence of this interstate councils and the usage, how it is to be used while legislating with respect to concurrent list. Clear? One very important factor which you can still see, which I have already discussed, but you can use it here, is the office of governor. Now, in legislative jurisdiction or legislative center state legislative powers, you should also see here you should also see all of this in the context of the powers that are enjoyed by the governor. Now, governor of the state enjoys the power to do what? Enjoys the power to reserve any bill for the consideration of the president. And if you see the constitution, under Article 200, under Article 201 and under Article 207, there is no specific time limit that has been mentioned. The time period in which the governor should dispose of with the bill. Once it is reserved for the consideration of the president, what is the time limit for which it should be reserved? This has not been mentioned in the constitution, which means if it is reserved, it may so happen that the president completely ignores it. And if the president completely ignores it, the state cannot work on that law. There is no such the law that will be formed. So in the manner the office of governor works, and Article 200 says it has the power to discretionary powers to reserve the bill. Article 201 deals with the idea of money bill. Article 207 deals with something in financial emergency. You will read there. We have already seen that. I have not discussed the article, but we have seen what it is. Any bill can be reserved for the consideration of the president. The president enjoys absolute veto in case of the bills that are passed by the state legislature. In all these cases, what we see is that sometimes these provisions can be misused to do what? To dilute the legislative jurisdiction of the state. So even the Punchi Commission also recommended that there should be a time limit that should be prescribed. A time limit within which the governor should reserve the bill and the president should take decision with respect to it. So even if the president wants to use absolute veto, the president should use it as soon as possible, so that the state gets a clear direction. Okay, there is a need for a law, but this law was not being accepted by the president, so there is a need to enact a different law with certain amendments, whatever. But it should be done within a specific time period. Clear? This is all about the legislative relations, some recommendations of Punchi Commission, and what are the problems with legislative relation between the center and state. Don't forget writing about the office of the governor. Clear? Next, administrative relations. So part 11 of the constitution, which deals with center-state relations, center-state legislative and administrative relations. Chapter 1 of part 11 deals with legislative relations, which we have seen. Now we come to chapter 2 of part 11, which deals with administrative relations. One more thing before we get into administrative relations. In the very first class, we had discussed this idea that in India, the constitution that we have, it is not a static document. It is a dynamic document. And that is the reason why the manner in which the constitution works, implemented, and the manner or whatever is written in the constitution may not always match. There is not 100% match in it. And that is the reason why if you look at the legislative relation between the center and the state, though this legislative relation specifically points out to the unitary tilt that is there, actually mein ye hai nahi. That means over a period of 70 years, we are in the month of January. Now we are going to complete 70 years of the Constitution of India. 2020, it was enacted in implemented in 1950. So 26th of January 1950 and 26th of January 2020. So we are going to complete 70 years. Over a period of 70 years, this legislative relation between center and state has rationalized. It has rationalized. And this rationalization is visible in the fact that the union and the state, or the union does not interfere with the state's legislative jurisdiction. They do not interfere. Yes, the constitution prescribes that there can be interference. There can be interference. But it actually does not happen. It actually does not happen. Over a period of 70 years, these provisions have been rationalized. So you will find seldom it is used that a residuary, any matter that is mentioned in the residuary list, it is being legislated upon by the Parliament of India. Or when it comes to concurrent list, though not mentioned in the constitution, but we have evolved certain mechanisms to take up this consultation. Like Going back to 1952, there was a body that comes up called as NDC, National Development Council. NDC was basically, it had a representation from the union as well as from the states. Similarly, today we have a body called as Niti Aayog, and Niti Aayog also has representation from center as well as from the state. If you see what the institution is all about, it says Niti Aayog is to be a think tank. ये लिखा हुआ है, think tank. So when it comes to legislations that are being made, in that case Niti Aayog is acting like a think tank as to what are the legislations that should be enacted and what are the current legislations that should be amended and new provisions are to be provided, whatever. That think tank idea is there with the Niti Aayog. And Niti Aayog again has membership from the states. And there are number of, when Niti Aayog is working, it works through various committees and commissions that are made, that are formed under the leadership of sometimes chief ministers of various states. They are considered to be the chairman of a committee that is made under Niti Aayog if it has to deal with some political issues as well as some other issues which has political ramifications. In that case, you will find either there is a union minister or there is a state chief minister which heads a committee within the Niti Aayog itself. So when I say that it has rationalized, why has it rationalized, or what is the mechanism that we see here over the last 70 years? We see bodies such as Niti Aayog, we see bodies such as NDC, and these bodies have evolved. And these bodies are basically rationalizing the unitary tilt. So the tilt that is present, to a certain extent, it is being rectified. एक तरह से बोल सकते हो, it is being rectified by the presence of such mechanisms. Clear? So just don't look at it from the constitutional angle. If you look at it from literally from the constitutional angle, you will find that the union government can do anything and completely disregard the activities of what the state legislature or the state government is doing. But the union does not do that. And this rectification that is there, it is very much visible when we talk about the administrative relations. So, wo unitary tilt is so visible in administrative relations, and how we do not use such provisions to rectify that unitary tilt is also very much visible under what we are going to discuss now. So, whenever you are commenting, suppose you are writing about the center-state relations and you are commenting about the center-state relations, don't forget to write the provisions or the mechanisms that we have developed, evolved to rectify this unitary tilt. Don't forget to write that, because if you just literally write what is mentioned in the constitution, examiner, if suppose an examiner like me, I will always expect that there is something more than what you have just read it in the constitution. I will always expect that, because that is what you read. When you go through the newspapers, when you look at this opinion pages, etc., that is there, when you look at the role of the states like CA and the protests that were being taken up in the states, how the Congress party led states that are there or some other party opposition led states that are there, they are saying that we are not going to implement it, and there has been number of articles that have appeared over it. So what is their jurisdiction? What is the constitution dictating? Is the union using the constitution to overshadow the jurisdiction of the state? All these things are what you are going to integrate in your answers. Otherwise, you are going to get average marks. So 15-mark question, if you get a 15-mark question, you are going to get 3, 4, that's it. If you write literally, if you write all the constitutional provisions without adding something from your side, only when you write that, you are going to get 7, 8. Now that is 50%, which means that 100 plus marks that is there, that is how I get it. Clear? Administrative relations. First, Article 256. Article 256. Which deals with the obligations of the states and the union. States and the union. The executive power of the states, the executive powers of the states shall be so exercised as to ensure compliance with the laws made by the parliament and any existing laws which apply in that state, and the executive powers of the union shall extend to giving directions to the state as may appear to the government of India to be necessary for that purpose. Underline this line. The executive power of the union shall extend to giving directions to the state. What is Article 365? Yes? Failure of constitutional machinery. Yes? In case of that, that will amount to failure of constitutional machinery. Yes. If you remember, when I was dealing with Article 356, what did I say? Article 355, Article 356, 256, 257, 365. All these provisions we dealt with. So when we say Article 256 and Article 257, why did I deal with Article 256 and 257? Because see what is written. The government, the union, the executive power of the union that is there, the union executive can give directions to the state executive. With respect to what? With respect to compliance of the laws that are made by the parliament and any law that is made in the state, that is applicable to the state legislature. And if the Article 365 says, if such directions are not complied with by the states, it amounts to breakdown of constitutional machinery. And when there is a breakdown of constitutional machinery, what is the consequence of it? Precedence rule, or the president can assume the executive powers of the state. Clear? Are you? No, now is it clear? So see, there are some laws that are being made, like Armed Forces Special Powers Act, extended to some region in the state of J&K. And now J&K, though it is a UT, so that does not count. But it was, even when it was a state, it was extended to the state of J&K. And the state executive, it was binding for the state executive to adhere to the directions of the union. Similarly, when we talk about the northeastern states, in states such as Nagaland, in states such as Manipur, in states previously in the states of Tripura, etc., it is extended. And when these laws are extended in such states, which means it requires that it is to be complied by the state government can take no action to contradict these laws. And for this purpose, if the union executive wants, it can give directions to the state, and the state has to comply with those directions. Because if it does not, Article 365 says it amounts to breakdown of constitutional machinery. Clear? Next, Article 257. It deals with control of the union over the states. Control of the union over the states. The union executive can give directions to the states in the following matters. First, the manner in which the executive power of the state shall be exercised as not to impede impede or prejudice the executive powers of the union. It cannot contradict it. The state's executive cannot contradict the executive power of the union. Second, the construction and maintenance of means of communication, declared to be of national or military importance, and third, measures to be taken for the protection of railways within the state. For the next paragraph, right? This is what is mentioned under 257. I am just adding something here. The Constitution also provides for a situation in which the state declines. To carry out the directions it has received from the union government. Article 365 lays down that where a state has failed to comply with the given directions, it shall be lawful for the president to consider the situation as breakdown of constitutional machinery. Breakdown of constitutional machinery. Clear? Just in brackets here write, directions are also given under Article 350 and 339 of the Constitution. 350 and 339 of the Constitution. Article 350 deals with languages, and Article 339 deals with basically certain acts for certain policies for scheduled caste and scheduled tribe, etc. Clear? So Article 339 deals with that, welfare of scheduled caste and scheduled tribe, and Article 350 deals with languages. And in both these cases also the union can give directions to the state. So that you are very clear with respect to what cases directions are given, I have just added 2 articles here. Clear? Now you have understood this. Administrative relations, these are the 2 most important provisions of the Constitution. Except for this, the other provisions, that is 258, 259, they are not that important. It's not useful for us. So I will not add the burden as it is. You are not studying whatever I am teaching in the class. So I will not add something that is not important. Clear? Just we are going to deal with only the important ones. Let's come to Article 262 directly. Article 262. Article 262. It deals with adjudication of disputes relating to waters of interstate rivers and river valleys. The Parliament may by law adjudicate any such disputes The Parliament may by law also provide that neither the Supreme Court nor any other court shall exercise any such jurisdiction in respect to such disputes So first thing is that when it comes to interstate rivers and river valleys, if there is a dispute between two states with respect to interstate rivers, it is resolved by the Parliament. So underline the term Parliament here. See, generally when we come to judiciary, when we start our discussion on judiciary, you will find that any dispute that is of this nature, that is interstate disputes that are there, the jurisdiction is of the Supreme Court. But in this case, the jurisdiction is not of any judicial body, it is with whom? The Parliament of India. To an extent wherein, if the Parliament by a law can do what? Can even through a law, even they can exclude Supreme Court from looking into or coming out with any such matters, looking into any such matters. Clear? Next paragraph. Accordingly, the Parliament has passed the Water Disputes Act. Parliament has passed the Water Disputes Act 1956, which empowers the central government to set up tribunals for the adjudication of such disputes. The tribunal shall consist of one person nominated by the Chief Justice of India from amongst person who have been or are judges of the Supreme Court or judges of the High Court. Clear? So in this case, under this particular law, tribunals are basically made, and tribunals, the legislature, the Parliament enjoys that right to come up with tribunals. And what is the role of tribunals? They look into such matters, etc. In this tribunal, at least one individual is nominated by the Chief Justice of India, so that the judicial view is taken into consideration as well. And he should have, either he should be a judge of Supreme Court, or had been the judge of Supreme Court, or has been the judge or had been the judge of any high court. If this is the case, then the individual is nominated for this. See, Article 262 of the Constitution, though it empowers the Parliament to legislate on any such, and to adjudicate, not legislate, adjudicate on any such matters, adjudicate in any such matters, but it can do that only by means of a law, which means it's not that automatically Supreme Court is excluded from looking into the matter. No. If there is a law made by the Parliament excluding the Supreme Court from taking up any such matter, only then the Supreme Court is excluded. That is the reason why you will find any tribunals, etc. that are there, their judgments are also appealed in the court. Supreme Court, it is appealed. Why? Because the law that has been passed by the Parliament, it does not exclude it from Supreme Court's jurisdiction. But if it does, it will be constitutional to do that. And see, here you have seen a very idea that I am not saying that the Parliament legislates. I am saying Parliament adjudicates, which means what? What is the meaning of this particular term, adjudication, or provide for adjudication? Yes? Judgment, additional judgment. It means that it is a quasi-judicial function. So when we talk about tribunals, what are tribunals? These are quasi-judicial bodies. They are not completely judicial bodies, but they are quasi-judicial bodies. So here you have written the Parliament may provide for adjudication. So who makes law? Parliament makes the law. And what does the Parliament do by making a law? No, it creates a tribunal which is a quasi-judicial body taking up such matters. Judicial, which means it awards sentences. Matlab, this much water goes to this state, this much water goes to this state. This is judicial in nature. It is being performed by tribunals, quasi-judicial body. Tribunal is a quasi-judicial body. Clear? Next, Article 263. Article 263, very important. Interstate Council. Interstate Council. If the President is satisfied that public interest would be served by establishment of a council, which has the duty of the following, first, inquiring into and advising upon disputes which may have arisen between states, Second, investigating and discussing subjects in which some or all of the states comma, or the union and one or more of the states have a common interest, or third point, making recommendation upon any such subject, for better coordination of policy and action, with respect to that subject, the president by order can establish such a council, and define the nature of duties to be performed, by the council. Clear? So I was talking about interstate councils and since then we have actually since 1950 we didn't feel the need to establish the council because बहुत अच्छा चल रहा था सारी चीजें, and in 1990 we did that. Clear? So for the first time we established the interstate council in 1990. Who is the chairman of the council? The prime minister. So what is the composition of the council? You can write it. Suppose a question is asked, so you can learn this composition, because the constitution does not define the composition. You can see it is the president who defines what is the organization and what will be the duties of the organization. So what is the composition of the council? You can write this. The prime minister is the chairman. The chief ministers of all states, chief ministers of UTs having legislature, administrators of UTs not having legislature, 6 union cabinet ministers, nominated by the prime minister, and governors of states under president's rule. Clear? So this is the this is basically the interstate council. See there, yes. No, interstate council is not, GST council is not an example of interstate council. Don't go by the term. Interstate council has a specific meaning under our constitution. Under article 263, it says president will establish it. President will define the duties, and what is the concerns? These are the duties that generally it will have in public interest. If the president feels the need, he will establish the council, and accordingly this council has been there since the 1990s. There are also something called as zonal councils. There is no need to write or something like that. You can search the net. You will find there are something called as zonal councils also. We establish zone wise. So all the states that are there in, suppose, the northern zone, so there is a northern zonal council, so southern zone, then eastern, western zone, northeastern zonal councils are there, central zonal council is also there. So there is also zonal council which is headed by the home minister. It is not headed by the prime minister. Clear? So this can also be a question in your prelims examination. But if you read the newspapers well, you will find that almost every year there is a meeting that happens. The chairman is the chief minister of the state. By they take turns to become the chairman here, but this meeting is convened, and basically it's like the home minister of the union home minister also participates there. Clear? Now administrative relations, again the unitary tilt is very much visible. Now, when we talk about center-state administrative relations and the problems that are there, problems of center-state administrative relations can further be classified into two. Some problems that have traditionally, or some traditional problems that are there, which means it has existed from the day constitution we have adopted the constitution. Like if we talk about the office of the governor, so discretionary powers, the governor has discretionary powers, and through the discretionary powers of the governor, the union can always interfere with the administration in the state. Similarly, Article 256, 257, 355, 356, 365, 350 and 339. Clear? So we have dealt with all these provisions. We know that all these provisions help the center giving directions to the state. And when it comes to giving directions to the state, what is the consequence of not following such a direction? All India services are also one of the problems that tends to appear between the center and the state when it comes to administrative relations, because I think day before yesterday or yesterday's class itself, we had seen what is the jurisdiction of the state executive with respect to all India services, or taking up any disciplinary measures against all India services. They do not have any disciplinary, the powers to take any major disciplinary action. So that is also a problem. So we have already seen these problems. We have discussed this. These are the traditional challenges that are in existence. So if you ever get an opportunity, generally whenever it comes to center-state relations and the problems that are there, it is upon upon administrative problems or administrative. What are the problems in administrative relations? So you can always talk about this, but we can also look at center-state relations and the contemporary problems. The contemporary problems, I am going to discuss some of the problems. What I want you is that, see, it very much depends upon how you prepare. I am going to discuss some of the problems, but every day that you read your newspapers and you find any such new problem that comes into existence between center and the state, you can always add it here. Clear? So what are the contemporary problems between the center and the state? Let's look at that. Contemporary problems. First, law and order. Law and order. See, there are two parts of this discussion. First part of this discussion is wherein what is the constitutional idea. The constitutional part dictates that law and order is a state subject. It is a state subject. So it is something that is mentioned in the state list. It's not mentioned in the union list. It's not the part of concurrent list. It is a part of state list. Hence, law and order as a constitutional idea, it belongs to the states. And it is the response when it comes to legislative jurisdiction. Now the state legislature has that. And when it comes to executive jurisdiction, it comes to the state executive, and the state executive is responsible for it. But because of two important reasons, we see that here there is a problem between center and the state that comes up. What are those two reasons? First, the reason is that law and order today, it has become a much complicated idea than what it was previously there. So today there are some issues such as Naxalism, terrorism, which are, no, they may not necessarily be limited to a geographical area. Naxalism, we have something called as a red corridor. Terrorism, it's prevalent across India and it's very much related. It has interstate links and consequences. Cyber security is something that does not have any territorial jurisdiction at all. It can be taken up wherever, and the consequences may be in any of the states. Because of these law and order related problems, no more having any kind of territorial limit to it, there has been a demand that law and order should be constitutionally amended out of state list and made a part of concurrent list. Similarly, when the states take up certain activities or the center tries to regulate it, there are some problems that happen between the center and the state. Example of it is an initiative that was to be taken called as NCTC, National Counter-Terrorism Centers, which was to be established under the Home Ministry, but the law was never passed because the states, they said that this is an encroachment of the center. Why? Because the parliament is trying to interfere with a matter which is in the state list. That also happened with communal violence bill, which was to be passed somewhere around 2011-12, but it was not passed. It was not deliberated upon because the states did not like this idea. It was considered to be an encroachment upon the authority of the states. Clear? Absolutely clear? Now let's look at the political side of it. ये तो constitutional हो गया. Constitutionally now you have understood this idea. Now let's look at the political side of it. Like if we look at the current aspect. There are some things that exists here, like lynching. There have been number of such cases. Similarly, there has also been something which we call as cow vigilantism. That is there. See, it may be a law and order related. It is a law and order related problem. It is a law and order related problem. Now, whom does the media blame for this? It is the central government which is blamed. So when any act of cow vigilantism is taken up, in that case, the media is blaming the center for it. Media is blaming the center for it. Now, there is a very there is an interview that is there in YouTube. It will be available. I think it was around 4 or 5 years. I was watching it. It was just before Bihar elections, the last Bihar elections that happened. Now, Amit Shah, who was then the president, not the home minister, so he was campaigning in Bihar, etc. So there he was addressing the media. No, not all of it. There was one of the news channels that are there. He was addressing them. So while he was addressing that media, so the individual who was conducting this interview, he asked him around 15 questions, and out of that 15 questions, almost all of the questions either dealt with these ideas, either it was with respect to communal violence or it was with respect to these two factors. He said, what do you want the center to do? On one hand, if today the union government comes out with a law, you are the one who will say you are encroaching upon the authority of the state. Because law and order is not a problem of the center. It is not the problem of the center. It is something that belongs to the state. So if you ask, now he specifically mentioned that if you want me to ask what has happened in Dadri, or no, it happened that Akhlaq case, you must have remembered that. So then it was in the state of UP, it was the Samajwadi Party who was in power. So he said, why are you asking me this question? Why don't you go and ask this question to Akhilesh Yadav? He is responsible for it. So he says, the anchor said that no, the Prime Minister has not said anything about it. So he replied that what do you want for the Prime Minister to do? If suppose you want that there should be a bill that should be introduced, you will be the one who will, and the states will claim that it is the center who is encroaching upon the power, because this is something that has already happened. This is something that has already happened when the law was to be brought about with respect to communal violence and defining communal violence, because in India there is lot of problems. Now what we do is, what media does is that they tend to show anything as a communal violence, but that is not necessarily the case. देखो रोजमर्रा की जिंदगी में भी वायलेंस होता है. It's not necessarily communal always. But that is not what the media does to sell what they have. They tend to make it with respect to communal violence. Because of that, the center wanted to introduce a bill that defines what is communal violence. It will define what will be communal violence. Now the states did not agree to it. So on one hand, when the states do not agree, and then you still hold the center responsible. You still hold the center responsible. So when the center tries to interfere, the state says, no, don't interfere. It is something that is ours. And when the center expects the states to do something, the states do not do anything about it. And that is the problem why Naxalism, which was something that started from one village in India, now affects more than 90 districts, and it has been reduced, considerably reduced, and it was go back to 2012-13, you will find 166 districts were affected by it. Something that started from one village, not even one state, one village. So this is a problem. And then what happens is that when the center wants to, now see, what I mean by saying that the media tries to blame the center. See, media is responsible for creating public opinion. And today, if as an individual, okay, I understand the constitution, you understand the constitution, you will be able to make this decision. Okay, this is not something that has to do with the center. But we tend to hold the center responsible for everything. And that is also true for the state also. We tend to hold the state also responsible for everything, the state government, I mean. And that is also true for the central government. But what happens is that here, because it is a part of state list, so the union does not interfere with the states. When it interferes with the state, it is considered to be an encroachment on the authority of the state. This is the problem. No, actually the constitution that you read now, there was one more provision to it, which was Article 257A. Article 257A of the constitution dealt with deployment of paramilitary forces in the state. It was actually repealed from the constitution. It was repealed from the constitution. Currently the law and order of the state is completely the responsibility of the states. And this becomes a problem. This becomes a problem between the center and the state. See, we know that there is a law and order related problem in the state of J&K. And in the state of J&K, in 2013-14, 2014, in 2014, when the state of J&K suffered from floods, it was this paramilitary forces who were deployed there, who actually, because of these paramilitary forces that were deployed in the state of J&K, the loss of life was very limited, despite the flood that was there. So on one hand, when you require paramilitary forces, तब तो ठीक है, otherwise उन पे पत्थर फेंकते हो आप, ठीक है. This is what is the case when it comes to law and order. Center is always in this dilemma that if they take up any actions or legislations with respect to law and order, it will be a violation of constitution. But आम आदमी को ये बात समझ में नहीं आती. So you will always blame the center for it. When the center wants to take an action, it will be considered as an encroachment over the state, and that creates a problem between center and state. Clear? Second. Bolo.
Law and order is in state subject. So, like, what is the procedure to change it from?
Constitutional amendment.
So, like, if the question asked to someone, like, one can change it from state legislation.
Yes, it can be done through a constitution. Everything in the constitution can be changed through a constitutional amendment.
And it will require the ratification of.
Yes, it will require the ratification of more than 50% of the states. Second is disaster management. Now in India, we do not take up disaster management. We, on the other hand, take up management of disaster. It's not disaster management, it is management of disaster. Why? Because if you look at a proactive approach towards it, which should be prevention, prediction, rather than entering into this field of prevention, prediction of disasters, what we do is we take up relief and rehabilitation. If you look at the disaster management approach that we have, it is about relief and rehabilitation. हो गया, उसके बाद चलो अब क्या किया जाएगा. It's not about prediction of disasters. It is more about relief and rehabilitation. Clear? 2005, we actually enacted a law which provided for a 3-tier structure of disaster management. Have you read disaster management? You will actually go through this law also there. There is a 2005 law which deals with disaster management. Post what happened in Gujarat, there was an earthquake in Gujarat in 2000, I think 1 or 2, somewhere around that. And after that, we started dwelling into this idea that we should come out with an institutional structure to it, and we created a law called as National Disaster Management Act. This National Disaster Management Act does what? This National Disaster Management Act creates a 3-tier structure. There is a National Disaster Management Authority, there is a State Disaster Management Authority, there is a District Disaster Management Authority. National Disaster Management Authority is led by the Cabinet Secretary. The State Disaster Management Authority is administratively led by the Chief Secretary of the state, and the District Disaster Management Authority is administratively led by the District Collector. Now in India, not only do we have these 3-tier structure, we also have we also have a force for it and a fund for it. There is a National Disaster Relief Force and there is a National Disaster Relief Fund. But what happens is when disasters actually strike, then we tend to find out that the state level authorities and the district level authorities that are there, they are absolutely useless. It is always the paramilitary and military forces which comes to the rescue in terms of disaster management. Why? there is lot of resources that is allocated to the disaster management bodies, but we never tend to question, okay, what is the NDRF doing? When the NDRF is responsible, that it is a force that we have created which is responsible for relief, disaster relief work. Why do we always require deployment of military and paramilitary forces to rescue? And not just this is obviously the institutional and the capacity related problems that are there, because national हमने force तो conceptualize किया है, but they are not being trained. They are not properly trained. But the problem is not just with respect to training. The problem is also with respect to coordination between the center and the state with respect to disaster relief. In the Uttarakhand disaster, that is the Kedarnath disaster that happened, in the Kedarnath disaster, one of the very basic problem was lack of coordination between the center and the state. And this lack of coordination between the center of the state delayed the deployment of forces, which further created a lot of problems. पता नहीं कितने लोग मर गए होंगे just because there was a delay in deployment of forces. And the best example of it, lack of coordination, you can see. When we talked about Mamata Banerjee did not talk to the Prime Minister. That is an example. Lack of coordination. So even disaster management is a problem when it comes to center-state relations. Clear? Third, coalition government. See, existence of coalition government is something that we conceive as a characteristic of a mature democracy. Characteristic of a mature democracy. Atal Bihari Vajpayee was once asked a question that what do you think about coalition government? And will the NDA, because elections was approaching, just before elections, he was asked, what do you think about coalition government? And you have just entered into a coalition with the AIDMK. They took up a coalition of AIDMK. So you have entered into a coalition of AIDMK, and till very recently, before they talking to you, they were talking to the Congress party. So how come you can be, you can come up with this, a political party, you can contest election in a coalition of a political party who has an ideology which may suit the Congress, and now you are also in a coalition with them. So what is the ideological similarity that you have, and why are you taking up this coalition government with them? He answered that in a democracy like that of India, you can never ignore the possibility of coalition. He said you cannot ignore the possibility of coalition, because democracy is about this. He said, do you think democracy can, even if tomorrow, he gave an example, forget about coalition government. He said that even if tomorrow I get more than 273 seats, I get 300 seats. But do you think as a political party, I can still be able to take up governance? See, he said laws can be made. Laws can be made without the support, because if I have the majority, I can, in the parliament, I can make a law, I can enact a law. But he said that when it comes to enactment of law and when it comes to administration of a country, enactment of law is a different thing altogether, and administration of a country is a different thing altogether. So he said, he was a very good speaker in Hindi. So he said, राष्ट्र चलाना और सरकार चलाना दो अलग अलग चीजें होती हैं. He said that if I have to only think about the government, I do not necessarily need coalition, but I have not only to think about the government. Yes, coalition will help me form a government, but I will also, because we live in a democracy, it is about coordination between all political parties. Today I may sit in the opposition, tomorrow I'll be forming the government. And today who is in the opposition, tomorrow they will come in the government and I will sit in the opposition. But when we talk about running a country requires coordination and coalition. According to this logic, if we go by this logic, existence of coalition is nothing, just a characteristic, something that points out to a fact that a democracy is maturing. Because it shows two political parties which may have different ideology, but to ensure that there is stability in the government, they have come together and they are running a 5-year term. It shows the maturity. And in India, since 1967, obviously, again, we have already discussed this idea how regional parties started coming, and in 1989, when there was actually no political party for the first time, when they did not come to power, no political party got the majority, a coalition government for the first time was formed. And this was something that was, it continued till 2014, and in 2014 and then again in 2019, it was something that we voted voted a political party with absolute majority to power. But we cannot deny that we live in a coalition era. Even if one political party has majority today, can the BJP run the country without getting the support of its coalition partners? It will not happen. But what do we see along with the existence of coalition government in India is that those states who have, or those regional parties who have supported the government, they tend to use this support as a factor to blackmail the government. Example hai TDP, Telugu Desam Party. In 2014, when NDA was formed, Telugu Desam Party and Chandrababu Naidu was very much a part of that coalition. He became the part of a coalition on a guarantee by the concerned government, that is the NDA government that came to power, that Andhra Pradesh, when they come to power, Andhra Pradesh will be given special category status. In 2014, when they came to power, when the Finance Commission came up with its report, it recommended that we should do away with this phenomena. Though it did not explicitly mention this, but since the 5th Finance Commission, it was the 14th Finance Commission which did away with this idea. So the states were given, tomorrow we are going to deal with this very idea also when we come to financial relations. So states were given more and more financial autonomy, with 42% of the total taxes should be given to the states. But the Finance Commission was also of the opinion that we should do away with this idea of special category status. So when the TDP asked the government to provide special category status to Andhra Pradesh, the government said that this is a phenomena that is already over. We are implementing the recommendation of 14th Finance Commission. Now, if we are implementing the recommendation of 14th Finance Commission, which does not anywhere talk about special category states, we are doing away with this. Now you want special category status. So they refused, because that will be contrary to what Finance Commission had to dictate. What happened? TDP left the government, left the coalition. And Chandrababu Naidu, he was till very recently the Chief Minister of Andhra Pradesh. And because elections were simultaneously held in Andhra Pradesh as well as in centre, so during that particular term, he lost power. And Chandrababu Naidu was defeated in the Andhra Pradesh legislature. But if he would have been in power, that would create problems between center and state. Why? Because coalition partners, they tend to do what? They tend to use the numerical, what you can say, that they become kingmakers, and they tend to do what? They tend to use this to their political advantage. This is also a problem. This is also a problem. Similarly, foreign policy. Now we have already seen that in implementation of foreign policy initiatives, or for that matter international conventions and laws, it is completely up to the Union Parliament. It is completely up to the Union Parliament. But what we also need to see here is that though it is completely something that belongs to the Union Executive, but what we also need to see here is that these, at least some of the peripheral states that we have, these peripheral states have a stake in certain foreign policies that are made by the government. Like the state of J&K or the UT of J&K will always have a stake in the relation that India enjoys with Pakistan. So if there is frequent ceasefire violation, who is suffering? It is the border areas, and J&K is a part of it. Similarly, when you look at the Sri Lanka, and when you look at Rajiv Gandhi's initiatives in Sri Lanka, or disasters in Sri Lanka, for which actually he lost his life also, what was there, the then Tamil Nadu government or the state of Tamil Nadu was not consulted. Though it is not something that constitutionally is mandated by the union government to do, but when you actually ensure that the peripheral states or the stakeholder states are involved in implementing foreign policy initiatives, it leads to better implementation of it. Like when we talk about the Bangladesh land border agreement that we implemented in 2014-15, it was an agreement of 1974 itself between Indira Gandhi and Mujibur Rahman. We were able to implement it in 2014-15. But when the center was implementing this, the center consulted the chief ministers of all the stakeholder states, including the state of West Bengal, Assam, Tripura. All these states were consulted. What was the result of it? Better implementation of it. So we cannot deny, yes, constitutionally the union is not mandated, but until and unless we ensure that the stakeholder states that are there, they are properly consulted, they are the ones who properly who are given the opportunity to have a say in these things, it will lead to what? Better implementation of these policies. Local self-government. Local self-government. Local self-government, again constitutionally speaking, it is a part of state list. It is a part of state list. But local self-government and development, they are related. Just look at the states which perform well in the HDI indicators. Do this. Go back to your place today and just check India's HDI ranking. See all the states, if you look at the Wikipedia's page, you will find that with every description that is given in a box, you will find their HDI indicators of states are also mentioned. What they score, every state scores on the HDI indicator. You will find that those states which are scoring well under HDI indicators, they are also the ones who have empowered local bodies. And those states which are the Bimaru states, there is an acronym called as Bimaru states. You will find that these states which are economically, they are not well developed, they they also face problems with respect to empowerment of local bodies. So development and empowerment of local bodies, they are related ideas. Now, do we hold only the state government responsible for developmental issues? No, we hold the central government also responsible for developmental issues. We hold the central government responsible for it. So there is a perception, okay, development, responsibility of the center. And the states tend to do what? The states tend to very easily manipulate it. Dekho, center is at a disadvantage here. Center will always be at a disadvantage, whichever government comes. क्योंकि states के लिए ये claim करना बहुत आसान होता है that we are not able to perform well because of the center. They are interfering in our matters, they are not providing us with adequate finances, and hence it is, so for them it is very easy to claim this. So what happens? When local bodies are not being properly empowered by the states, they are not properly being financed by the states, and center, which has a role in development, tends to do what? Tends to interfere in the working of local bodies. We are going to talk about a commission called as Finance Commission. You will find when we look at Article 280 of the Constitution, it elaborates what is the responsibility of the Finance Commission, and it says it will recommend on local bodies as well. So it does that. Go and read the terms of references of 15th Finance Commission. You'll find local bodies will be mentioned there. Last Finance Commission also did the same thing. It recommended 2,79,000 crores should be delegated directly, it should be given to the local bodies. This was a recommendation given by the 14th Finance Commission. So the center interferes, states will claim, okay, this is an encroachment on the power of the state. Center बोलेगा फिर पैसा दे दो, नहीं पैसा नहीं है. So they will not give them money, but they will also claim that there is an encroachment of power. Clear? So these are some of the contemporary issues. There can be more as well. The more you read newspapers, the more you go through these topics, please, anything that you come across, you can add here, and always see this, always interpret this in light of what the Constitution has to say. Article 256, Article 257, Article 262 of the Constitution, Article 263 of the Constitution. Remember this. Clear? With this, we complete our discussion on administrative relations. Tomorrow, we start with financial relation. We complete financial relations. So, tomorrow we complete the center-state relations. And then, most probably, we move to the next topic, that is local bodies. Thank you.